So myself is Manu Jandal. I'm advocate in India and barrister and solicitor in Canada. So very good evening to all of you who are in India and very good morning to all of you who are in Canada or in any part of the world. Maybe good afternoon to few people. Let me say you few things to you before we come to today's class. You are most welcome. You are all lawyers in the different parts of the world, and I'm really pleased to welcome you all. And one thing I would like to say that you all are very, very, very experienced. You may have completed your education, or you may have kindly mute all of you. My request, genuine request is please mute yourself. Thank you. Uh, you all are very experienced in your home jurisdiction. You may have practiced for few years or few days or say good number of years in the courtroom. You may have rubbed your shoulders with the seniors or you may be one of the senior. I have seen in the today's list that there are persons who have done PhD. So it seems that there are very many experienced persons. As far as me is concerned, I'm a lawyer in India for 22 years. So I have been practicing here in all the forums, maybe district level, state level, or national level in India. I'm a barrister and solicitor. I was licensed last year in August 2021 due to some immigration issues. I'm here only in India, but I have dedication for these teaching purposes. So I'm continuing with the NCA teaching, and very soon I will be coming with the barrister and solicitor classes as well. So after giving an introduction round, you are most welcome. If anybody wants to say anything or wants to ask anything, you can unmute yourself at any point of time in the class. But my humble request to all of you, be very precise and be polite to everyone whosoever asks the question. For me, I consider every question is a very, very good question, maybe of general nature, maybe regarding foundation. So please don't hesitate to ask any question, although we have requested to all of you to mute, but still you are competent to unmute yourself and ask the question. And let me say you one more thing, that interactive class is always a good class. If I keep on telling you the things, then it will become boring. Some of you may be sleeping by the time I end up the class. And frankly speaking, this foundation subject is little bit lengthy. I won't say it is very lengthy, but it is little bit lengthy. You need to understand the concept there and then. That is why I am making time and again request to you. You can stop me anywhere you don't follow, but please be aware. So before we
Hello.
start, please go ahead.
Do you really think it is going to be offline?
I already told you that this is something in the air, but due to certain developments which has taken place in Canada from March onwards in LSO, Law Society of Ontario, there are certain investigations going on in examination leakage systems. So that is why that is in the air. LSO has already gone offline, and there is a debate going on in Canadian society about the online pattern of examination delivery. So
The
that is
NCA
why,
exam.
pardon?
The NCA examinations.
No, I'm talking about Law Society of Ontario. So there is a debate which is of journal nature going on, whether the delivery of the online examination should continue or not. That is in the air and that is in the press as well. And keeping in view that debate and the recent meetings held of NCA and LSO, Confederation of Law Societies of Canada, uh, that is something probable.
Okay. Thank you. Thank you so much. So nice of you.
I also have a general quick question.
Please.
Like, as the exam is in July and then exam duration is getting reduced from 3.5 to 3 hours. So will there be any change in the question paper pattern, like reduction in number of questions or something like that?
Same question is in my mind. But let me say you, I don't have the ready-made answer for this. Let us wait until NCA unfolds the whole story.
Okay, sure. Thank
In
you.
any case, it is not going to be offline before July.
I don't want to say anything because it's an administrative decision to be taken by the NCA, and keep guessing.
Okay, thank you.
So let us start with the today's class. If any other query, you are always welcome to unmute yourself and say the question, ask the question, or if even if you want to share an idea in between, you have some like if I have made any error during the whole process, you can correct me at any time. So I would welcome all of you. So the point I was making before we started the question, NCA is very easy. Since you all are very experienced in your home jurisdiction, the biggest thing which people think or say when they start teaching NCA subjects, they think that you should leave whatsoever you have learned, whatsoever you have done in your home jurisdictions, or as far as your experience is concerned. But my way of putting it, presenting it, thinking it is different. You always carry your experience, your expertise with you whenever you are going to attempt NCA exams. So my sincere advice to all of you, whenever you are to attempt any exam, particularly the NCA exam, NCA is not looking forward for any cramming thing. They are going to analyze your conceptual ideas which you have learned while preparing for NCA exams. That is why they have made it an open book exam. And passing the exam is very, very easy. Why so? Because you need just to score 50 marks. And if you are already aware, then it's good. But let me put it in proper perspective as per the NCA policy. Whenever you score 50 marks, examiner stops checking your exam. You are declared pass. But God forbids, if you do not score 50 marks during the whole of the written exams, then the examiner needs to write a failure report. Means to say he needs to describe every mark given to you and what are the shortcomings in your exam. So keeping this point in mind, I conceive that NCA exams are very, very easy. When I attempted approximately 1.5 years back, 2 years back, I cleared in first go, first attempt. Then came the turn of barrister and solicitor exam, same is the case. But let me say you, hard work is the key to success, which you already know. You have to close yourself in a like calm room, take a deep breath, and then prepare for the exam. Why I'm saying so that you have to keep yourself calm? Because NCA is permitting you to take all material. You can prepare your notes. You can take your hard copies of all the notes, maybe purchased from somewhere, maybe books. You can take your cheat sheets. You can take your charts, everything which you can visualize in the paper form. You can take in the exam, whether it is online or offline. So once NCA is permitting you to take everything in your exam, now you have to conceptualize this idea in the very beginning of this foundation class. That what is this exam? This exam is about that how you read, how you analyze, and then afterwards how you put your ideas on paper. Of course, there are certain set rules according to which you have to attempt your exam. But once everything is available with you, so you do not need to cram even a single thing. The basic idea which you may realize when you are approaching the exam 2 days back, 3 days back. You may feel that we have spent a lot of time in memorizing the things. But if you pay your attention to the concepts and then to apply the concept in proper perspective as per the exam question, then nobody can stop you to clear things. That was my idea. That can be your idea. So let me say you very, very frankly, in the very first attempt of my introduction to you, if you follow class instructions, clear your concepts, nobody can stop you to clear the exam. And lastly, as far as the examination preparation is concerned, a teacher, maybe me or maybe somebody else, if you come across somebody else, I would like to say everybody gives you good instructions, good teachings, good in his or her own way of giving you the conceptual clarity of the subject. But it depends wholly, solely upon you, how you conceive those ideas, how much you follow those ideas, and how much you practice those ideas in your exam. So my sincere advice to all of you in the very beginning, please pay your proper attention whenever you are in the class. And once you complete your class, give at least 10 to 20 minutes to revisit the concepts which you have read in the class. That is true with respect to foundation class, but also true with respect to all other NCA subjects. And one last thing at the cost of repetition, I would like to say, whatsoever you are carrying from your home jurisdiction is very much true throughout the world. So that can never be wrong with respect to NCA. We can differentiate always, but keeping in view the syllabus, keeping in view the length of the ideas in foundation, we will not be going to the comparison chart with respect to the different countries. But surely, whenever there will be question, I would try to answer that. So let us start foundation. As
One
far
question.
as, yes, please.
During your entire this course, will you tell us how to exactly attempt the question, the IRAC? To be frank, we are not very much conversant with this idea in India. Do you understand?
I understand, but you are saying this idea even keep bothering all persons or most of the persons till the exam starts. But two things I would like to say in reply to your question. First is that in foundation there is no I. As far as the others are concerned, there is IRAC system. Whenever I would attempt, I would try to give you the examination pattern. I would keep on clarifying that idea. But as
Okay.
far as foundation is concerned, let me say, you have to conceive the idea first. Why I have stressed on one point in the whole of the our WhatsApp group, that you should read syllabus.
Okay.
Foundation is the, thank you, and foundation is the only exam in which I would like to say that if you do not carry your syllabus in the examination, it will be hard to attempt the exam. Whenever we will be having our third, fourth, fifth regular classes, means to say this is also one of the first regular class. Once we learn few things, then we will be able to analyze that what is the importance of taking syllabus in the exam. I would like to give you an food for thought that my point of stressing upon the syllabus, going through the syllabus is that in foundation, when you read any question in the exam, you need to visit your syllabus. Any question. Suppose you have 5 questions in your exam. You have to take your syllabus, see whether it falls in this chapter, what is the main concept, what is the major concept, what is the minor concept. Of course, I will be describing you each and everything. But let me say you one thing, this syllabus is very important. That is why I want that you should have a habit of two things. First, reading the syllabus time intake, which people hardly do with respect to other subjects, but as far as foundation is concerned, you must. Secondly, you must note down certain things upon the syllabus itself. If you will jot down certain things upon the syllabus itself, which I ask you to carry in the exam, then you will be very comfortable rather than seeing notes time and again, rather than bothering your mind, that what is contained in a particular case, in an article, because there are various articles, those are lengthy one. And once you have the crux of the article or the case on your syllabus written, then you don't have to bother your own self before the exam and during the exam. Before the exam for the purpose of preparation, during the exam for the purpose of attempting the exam. Now, let us try to understand what foundation subject is, then we will come to the chapter 1 today itself. And my endeavor is that let us complete first chapter today itself. And believe me, once you go out of this class, you will feel very comfortable and you will say that if any examination question comes from this chapter, we are good to write the answer. So the first point in this foundation Canadian subject, you have to identify the major topic. Whenever you, if you all of you may have pen and pencils with you, you can note down and make a note on the first page of your notebook. And you should have a habit in the class of foundation of jotting down the things which are taught in the class. First, you need to, whenever you read an examination question, you should take a deep breath and then read the examination question. Why I'm saying to take deep breath? Why? Because I do not want to make you afraid of the questions, but still, in foundation, the questions will be little complicated. After reading most of the questions, you may come to the conclusion that this is pertaining to this topic. And after a few minutes, you may come to another conclusion that this is pertaining to some other. So that is why syllabus comes to your rescue. So the first point you should jot down is identify the major topic. What the examiner is asking. What this question is all about. Second is you have to see from whole of the syllabus. I'm not saying from the first chapter, second, third, fourth, or any chapter, that you have to analyze which case law is the best to quote in this answer. So first to note is that identify the major topic. Second to note is identify the case law. Then the third thing which you need to note down is that we have read so many articles. We have read so many articles during the whole of our studies of foundation. Which article and which part of the article is best suited for this question? Then comes the first chapter. What is first chapter? Legal theories. I was telling you about something basic concept. Am I in a moment starting the first chapter? No. I'm trying to say you all that you need to identify where first chapter can best fit in your answer. What is the first chapter? Legal theories. Legal theories means to say, what is the foundation of Canadian law based on legal theories? And most of the questions, almost say all the questions, you have to, I'm using the word have, you have to include some part of legal theory, which is best suited you to your answer. So let us repeat one by one. Identify the major topic, identify the case law, identify the article, expert opinion, you can call it as. Third, fourth is legal theory. First chapter, best fitted. And once you identify these four things, you're good to write the exams, answer to the exam. So some of my friend has asked in the very beginning that how to write the answer. So this is precisely the answer is. You will say that I should tell you what can be the first line, what can be the second paragraph, what can be the fifth, what can be the concluding paragraph. Of course, I will come one by one. But if you follow this pattern, once, suppose I will give you one journal example. Say you may be mother, father, or you may be son or daughter. Your mother asked you, go in the kitchen, find out something, say salt. You go in the kitchen, try to find out the salt, come back after 5 minutes, say, I don't know. I couldn't find the salt. But if your mother do tells you where the salt is lying or what the salt looks like, or you yourself know, then you will be in a better position to bring it in a few minutes, few seconds. So as far as the time frame is concerned in the examination, NCA is not only going to evaluate how you attempt the question, but they have categorically mentioned in their policy that they are going to analyze that in the given time frame how you are going to attempt the exam question. So if you are good to go with these four things, identify the major topic, identify the case law, expert opinion, as well as the legal theory first chapter, then of course you will be able to find out the salt. You will bring the salt, give it to your mother. Why I'm saying so? Because when you correlate your theories or ideas with day-to-day life, I suppose it is better to remember. So to attempt, first point is there is no IREC system in foundation. And how to attempt? I have told you the pattern. Identify the major topic, cover the major topic, quote the case laws, write down the relevant part of the article. Then I suppose once you do it, then you will be good to attempt the exams. So we are going to read lengthy syllabus of Canadian foundations of Canadian law. Please remember these things. How to identify major topic, I am going to tell you how to identify the case laws. Of course, you will able only to identify, as I have given you the example, if you know the things in the proper perspective. If you know about the salt, if you know about the salt container, if you know about the place where it is lying, then you are good to find the salt. Similar is the case if you know the major topic, if you know the case laws, if you know the articles to be quoted, if you know the legal theories to be made part of your answer, then you are good to attempt the exam question. So my humble suggestion to all of you is keep all these things from the very first day of our learning about foundation of. Now let us come to the syllabus itself. I will read it for you, or I will choose in the later part of the class anybody who can volunteer, or I can make a request to read. But for the time being, components of the first chapter are basic theories of law, racism, and the law. Why I am reading? Some may think that we have already read. What is the fun of reading? Because this will gives you an insight that you have to look this syllabus in the exam time and again. Positivism and natural law, feminist perspective on law, critical legal studies, law and economics. And required readings are three case laws have been recommended by the NCA: R versus Morris, Canadian Incorporation 8573123, Canadian Incorporation versus Calais Shepherd Plaza Incorporation, R versus Gladio. Then an article by Robin Maynard, Arrested Injustice. So this is what the first chapter is. This contains 5 theories. What are those 5 theories? Let us go one by one. Let us understand. I will give you theories, name of the theory. I will give you the case law. I will make you to write 1, 2, 3 lines about every theory. If you jot down these things, of course, in the later part of our classes, I am going to give you the notes as well. Notes, of course, which you can use, which you can refer in your exam. It is very easy. Let me say you about notes, 1, 2 lines. Let us talk about this arrested injustice article. I will share my screen and give you little bit of insight. Just a moment, please. Can anybody say me that everybody is good with this? Everybody has access to this article?
Yes, it's visible. Thank you.
Thank you. And if you go through, this is the article. I have done nothing. I have just downloaded it from the link. What I am going to do is, this is something 33 page art, 33 like 33 pages article, Arrested Injustice, from the streets to the prison. Just visualize in your mind, take a deep breath, and then go to this arrested justice, no, injustice, no, arrested within brackets injustice. So the author is talking something about whether the justice is being done or whether the justice is there or from where. From those protests to the last stage of the judicial system, that is the prison. Once a person is held guilty and sent to prison, whether the justice is imparted to a class of people there. Of course, we are going to read today itself. The point which I wanted to make by sharing this screen is, if you go on checking this article, you will find that this is very long article consisting of 33 pages. What I am going to do it for you, for all of you, that I will make it 1 page. So the point which I want to make, can you write down 1 page in the exam for a single article? I'm afraid we cannot. You can write few lines. So now let us analyze the whole concept of notes. The NCA has given you an article of 33 pages in the first chapter itself. I will make it 1 page, 1.5 page in my notes. Of course, I am going to describe it in the class. Then from that 1 page, you need to pick few lines. If those are quotes, you have to put it in your exams as it is in the invited commas. But if you do not have those, you can write few lines in your own language. So that is how I'm going to make things easy for you as far as foundations. 33 pages versus 1 page. There will be different articles in different in the whole of the syllabus. There are various articles I have not counted. Even I have not counted the case laws. I have just highlighted. I would also like to request all of you to kindly highlight as I have done. I will show you that all of you should highlight. You should buy some markers from the market, then highlight case laws with one color and articles with another. And of course, you should use either pen or pencil on the syllabus itself and write one line which I am going to tell you. Today, we will be talking about first chapter, so I will be going to tell you today more of a procedure. But still, it is very, very, very important. The point is that once you have read this first chapter, you have highlighted these with colors, you have jotted down few lines. I have jotted down few lines for myself for the purpose of teaching. I have used lead pencil, and by this lead pencils, I have write few lines. And once I understand the concepts, I'm good to write anything on that subject. Of course, we have the whole material with us in the exam. So my learned friend who has asked this question, that he has made my teaching very easy for the day, that I am able to tell you how to attempt the exam question. These all are the tools to attempt the exam question. Now let us study the concepts. I have told you how to attempt the exam question, how to identify major topic, precedents, articles, legal theories. We have read the components of the first chapter. Now let us jot down what is legal theories. I can ask you even, I will keep on asking you people, and please, I request to all of you in these two classes as well and in the classes to come. When if I pinpoint anybody, ask anybody, anybody can say past, but please unmute yourself whenever I ask. I don't, everybody should volunteer, and I do not want to offend anybody. If not knowing is not a fault, but not learning is a fault. So my thinking is, if you are not trying to learn, that is your fault. But if you are not doing, that is not your fault. So whenever I ask you, please unmute yourself or volunteer yourself so that you can best participate in the class. So let us jot down 5 theories are there. Legal positivism in the first theory. Second is the natural law. Third is the critical legal theory. Fourth is the feminist legal theory. Fifth is the law of economics. So these are the 5 theories. What we are trying to learn? We are trying to learn foundations of Canadian laws. Whenever a law is made, there is a theory behind it. Why a law is made? How a law is made? You may have seen in your home jurisdictions that there is demand of certain things, or there is a political will behind certain demands, certain orders to be passed, then a law is made. But with what purpose? If you read out any law in anywhere in the world, you go to any of the countries, Canada, India, USA, Pakistan, or anywhere, you will find first like even if you read the constitution, preamble is there, which describes the purpose of writing the constitution. In Indian constitution, whenever a law is there, there is a first, what is the purpose of making the law? What is that purpose clause? That purpose clause is based on some theory. We can watch that some theory is the guiding principle for bringing that law into daylight. Once you know that purpose, once you know that theory, then you know that law. Suppose firearm acts both in India and in Canada too, in USA too. firearms means to say a law which regulates the firearms. Maybe how to operate the firearms, how to keep the firearms, how to manage the firearms, what are the prohibition of keeping the firearms. Means to say, if I go with this example of firearms, then of course there will be something which will be coming out, that what is a theory behind. There may be certain persons who may be willing that everybody should have possession of at least one firearm. There will be another persons who may be of the opinion that firearms are not required. If you possess the firearm, you can misuse those firearms. This is another theory. Another theory is that to safeguard one's life, firearms are necessary. Another theory is that a person below a certain number of years of age should not keep or carry the firearms. So these are the theories. So theories of laws makes the laws. Whenever you go in the spirit of any law, you come across a legal theory. So whenever you read any chapter in the foundation, that chapter, that law, that concept is based on some legal. That is how, when you are to write your answer in the foundation exam, you need to give reference to one of the theories if possible. There will be certain concept where the theories won't be applicable and you need not to refer to the theory. But most of the time, you need to write, even if the examiner is not willing to ask you, you need to put down few lines from one of the theories which are most relevant, that this theory is the guiding principle behind this law. Or you can put some words, or you can refer to one of the articles from the legal theories, or which is most relevant to the answer. So we have jotted down 5 legal theories. Now let us go one by one. By the end of this class, you will feel that we have done the whole chapter, and that is very, very, very easy. Once you know why the legal theories are necessary, what are the legal theories? I have just described you with an example of Firearms Act, which is there in Canada, which is there in India, which is there in US, which is there in almost every country. Because earlier the people used to keep different sort of firearms, and there is a debate about firearms definition as well. Even if anybody has attempted criminal law in NCA or back home, whether this pen can be a firearm. As per the Canadian Criminal Code, if used as an arm, it can be a firearm. Then many may disagree. In our class, when I was a student of NCA, many agreed up to the last that this pen can never be a firearm. I was teaching somebody, I won't name that fellow, that a simple pin can be a firearm. Pen means to say paper pen. All pin or paper pin can be a firearm. And I have the relevant case laws regarding to that. In India, there is a particular case law with respect to the pen being used as a firearm. So let us go back to our foundation, because once I give you example, if you keep those examples in your mind, it's very easy for you people to remember all those things in the exams. And I told you NCA is looking for your concept rather than your descriptive theories. Now let us attempt first legal positivism. This is an idea conceptualized by certain people. You may agree, you may disagree. I may not be agreeing to that. But all these theories are based on certain ideological factors. Now let us see what is the ideological factor behind legal positivism. Rule is rule. I have started today's class. I have requested you that kindly mute yourself. This is a rule. You all have abided by it. I'm thankful. This is a rule. But simultaneously, I have given the permission. Anybody can unmute and ask a question. This is again a rule. So now, any one of you do not have a question, but still want to speak something. I have not allowed for the same. Can that be covered under this rule? No. So whether that can be covered under this legal positivism? No. Because legal positivism, one line which you must note down in your mind as well as in your notebook, rule is a rule is a rule. Rule is a rule is a rule. And the believers of this theory says that we cannot deviate in any manner from these rules. Suppose in casino, if anybody wants to go to casino, the legal age for entering the casino is 18 years. One of the guy who is accompanying you is 17 years, 360 days. Now a person who is a believer of legal positivism, whether he will allow him to enter the casino or that is my question. Anybody can volunteer, unmute and answer. And please tell why.
No, sir.
No,
Answer is
because rule is rule.
Thank you. And very well said. And rule is a rule. 5 days or less, not complying with the rules, not allowed. This is legal positivism. You are driving on a highway. Speed limit is 100 miles. Anything is to say for the sake of instance, 100 miles. Traffic gun, which is there to note down your speed, notes your speed at 101, whether you are at fault or not.
Definitely yes, sir.
Yes.
So nice, and thank you again. And if you are at 101, now some of my learned friends may say that, sir, 5 minus plus is allowed. I may agree with all of you, whosoever is believer of this, but legal positivism theory does not believe in this. They say if you
Sir,
are
it's not,
sorry,
sorry,
please.
sir. Sorry, sir, for interrupting. Sir, in Canada, last week, the police guy gave a ticket for the guy was on 111. Now the speed has increased. It's now 110 on highway. So they have given ticket for just 1 kilometer. So that's he argued for that matter. But policeman said rule is rule, man. You can't. We have increased the speed. In spite of that, you are going up, even if by 1 kilometer.
Thank you for making the class lively, and thank you for the example as well, Mr. Komal, I suppose. I identify his voice. So you are right. You have given a live example since you have you have just returned from Canada. But in Australia, this is a rule. In Canada, that policeman might be on that side, but law says that 5 minus or plus is allowed, but they are non-believer of legal positivism theory. Their law is flexible. We will come to the next theory even. But what I want to make is rule is a rule is a rule. You do not need to see that 1 kilometer cannot be adjusted. So you should be either below 100 or maximum up to 100. If you crosses the 100, you have violated the rules. You have to be given the ticket. Good to go for the fine. But if you go before with the ticket, if you go before the judge, then it depends upon the judge. So the case to be quoted into this is Noble versus Wolf, 1948. That is a judgment which brought about this legal positivism into a case law in Canada. We have, this is something good case law which we have to mention in our exam if we are mentioning this theory of legal positivism. What happened in this case was that somebody purchased a lot. Once the person, any noble was the person who purchased a plot and wanted to sell that plot. That when they purchased that plot, the purchase deed contained a clause that it cannot be sold to any Jewish or Hebrew person. So the moment, but any noble wanted to sell it to some Jewish or Jewish person, the case went to the court of law. The judge held that they cannot, because that this decision is based on legal positivism theory, that rule is a rule, since the basic purchase deed contained a clause in which it has been disallowed that it cannot be sold to a Jew or to a Hebrew person. It may be contrary to the discrimination laws, but still the judge said rule is a rule is a rule. So you cannot sell it. So the sale was disallowed. So this is what is legal positivism. Legal positivism is
Sorry, I'm interrupting with me. Can you please repeat the citation?
Noble versus Wolf, WOLF.
Thank you so much.
Am I clear on this theory to everyone? If you have any question, otherwise we will move ahead to natural. No question is means I'm teaching good, little bit satisfying for me, but still I would always like to answer the questions. Now let us move to natural law. Second theory, we have covered one. We have given the case law, we have understood the theory. Now we are to understand the second theory in 2 lines. We have enough material to give in the exam regarding the legal positivism. We have learned the case law, we have learned the facts, we have learned what is the takeaway from this case law. Of course, if you have to disagree with this theory, you may write down in your exam by quoting this theory that this theory believes in this manner, but we do not agree with this because this is a discrimination. Though this theory is believer of the fact that rule is a rule is a rule, but still in the modern times, whenever the rule discriminates between the persons, which the charter, Canadian charter does not allow, it may be nowhere have current standing in the course of action in the current law. You can give your, what NCA people are going to judge you. Let me give you one golden formula. What is that golden formula? In Canada, Canadian study system, I'm making a very bold statement, and I'm very confident while making that statement. In Canada, conclusion, in Canadian study system, conclusion never matters. They want to see what you want to say, whether you can justify your statements or not. In NCA, you cannot throw the material. This thing is this thing is this. You have to interwoven your result in your answer in such a manner that you can justify whatsoever you have taught. Like you have mentioned this theory of legal positivism, and if you do not agree, you say in few lines that this theory now like put certain persons in a state of affairs where discrimination cannot be avoided. So we cannot like believe that this theory is good to go in the contemporary times. If you write these few lines in your own words, then the examiner will be much impressed and going to give you bonus points, because you have been continuous in writing your opinion in the exam. So now let us study the second. I have told you the golden principle for all NCA exams. Suppose you are attempting criminal exam. We are not attending the class of criminal law, I know that. But if you are, many people ask whether he has committed first degree murder, second degree murder, manslaughter or something like that. I say that it does not matter what he has committed. It just matter what portrayal your answer is giving to the examiner. Similar is the case with foundation. Similar is the case with administrative law. Similar is the constitutional law. Similar is the PR. PR is a little bit different, but I will put it in this manner alone. So the golden principle is Canadian study system does not believe in conclusions. They believe in your ideas presentation, application of the law. So now let us move to natural. Natural law say that rule is a rule is a rule. Good. But we should be flexible, little bit flexible. Our car goes from 100 to 102, 105. It is okay. Good. We have never attempted to violate the law. It was just that we cannot control the speed to such a perfection that it can go little more beyond it. It's good. So the believers of this theory believes, natural law theory believes that morality should be given its place whenever a decision needs to be given, to decide a particular point in the court of law. So the second theory is morality first. First, natural theory says that morality should be given the first place in the law. Suppose your car goes beyond 100, never mind, little bit. But if it is going, say, 110, then it's problematic. But if it is going up to 15, 16, good. So the believers of this theory believes that human consideration should be given paramount importance in the law. This is the crux of this theory. To one line, if you need to write down, morality is the first principle which should be followed while implementing the laws. So there should not be so much strictness. The case to be quoted into this is Drummond-Wren, Drummond, WREN. This is judgment prior to that case, Noble and Wall. So Drummond judgment came in 1945. What happened in this case is a lot was purchased with the intention of building a house by a society, by a charitable society, namely WEA, purchased a lot with the intention of making a building upon it. Then they were not in a position to build the house in lack of the funds. They had to sell that plot. Now, when they bought that plot, the one prohibition was there that it will not be sold to Jews or any person of objectionable nationality. They incidentally they came across a person who belonging to objectionable nationality. We are talking of olden times, 1945 or little prior to that. When the case went to the court, the judge decided on the basis of morality, on the basis of natural law, that now the water has flown. time has gone when the covenant was fixed. Now, flexibility should be given, and the land can be sold. So, Drummond case talks about a flexible view of the law. That is, even if covenant is there that you cannot sell a land. Now, this covenant is not specific. You cannot sell this land to B, C, D. No, this is something is of general nature. Moreover, this is not a contract between two parties. If it would have been a contract between two parties, then it is a futuristic concept describing one covenant in which condition has been laid that it cannot be sold to a Jew or a person of objectionable nationality. Now, the thing to be learned is that a judge took a holistic view, or you can say view based on the morality, that since the time has gone and now this covenant is against the public policy. What the public policy says that nobody should be discriminated on the basis of like nationality. So keeping this view, this theory in mind of natural law, the judge allowed the lot to be sold to a Jew or a person of objectionable nationality. So this is the case Drummond ran. So if you keep on understanding the concept and understanding the case law, I suppose you will be very easy to remember all these points. If I will start teaching you very difficult language written in different sort of notes available in the market, then you will reach nowhere because in the exam you need to describe the crux of the matter. You need to write few lines about the theory. Generally, there is not a question, full-fledged question upon the theories. Even if that is there, you have enough material to write, since you can quote one case law and you can give little bit elaborative viewpoints in your own language. So now we have learned the second theory. May I have any question if anybody has got any doubts?
Sir, can you please tell the case law once again?
Pardon?
Can you please
Little
tell the
louder,
case
please.
law once again? Sir,
Case
can you
law,
please
I
tell
would
the case
repeat
law
it.
once again?
Would you please come again? I'm hard to hear.
Sir, can you please tell the case law once again?
Okay. Case law is Drummond. D-R-U-M-M-O-N-D. Drummond Wren. 1945.
Excuse me, I have posted it in the chat box also. So the spelling is correct.
So nice. Just a moment. Let me check. Yes. Mr. Ashish has done it. And thank you very much, Mr. Ashish.
Welcome, sir.
Let us move little further. Third theory. Critical legal theory. We have seen what the positivists say. Now we have also seen what the natural law thinkers say. Now let us study what the persons who are believers of critical legal theories, what they have to say about the ideological difference between the other theories. They say that the rules are subject to interpretation. How you interpret the rules, that is of much importance. And who interprets the rules? Judges. Critical thinkers, critical legal theory thinkers says, person who believed in critical legal theory, they say that all depends upon the interpretation of it. And there can be 100 interpretation of the same. And let me say you very frankly, Supreme Court's main job is to interpret the law. And they are keep on changing their interpretation with respect to the times. So the believers of critical legal theory says that the interpretation is the key point which matters with respect to it. And who interprets the laws? Judges interprets the laws. And whenever they interpret the laws, they cannot keep their personal ideologies, background experiences out of it. They will always include their personal ideologies, personal experiences, their personal endeavors, how they think about those rules while interpreting the rules. So the believers of critical legal theory says that the judges do play the most important role in interpretation of statutes or interpretation of laws. And those are generally influenced by their own personal ideologies and background experience. So the case to be quoted into this is R versus RDS. RDS, not X. Sorry for that. RDS, 1997. I would like to say one more thing, that whenever you need to think, you always think from a logical person's aptitude. Once you think, even if you do not know the answer, start thinking from a logical person's perspective, you will find out the answer. Critical legal theory says interpretation, which is the key to the any rule or law. So the case to be quoted, as I have already told you, R versus RDS, 1997. It's a Supreme Court ruling, Canadian Supreme Court ruling. The facts of this case are: a white police officer arrested a black 15-year-old boy. What he has done, it is of less significance. The point which I want to make you is, a white police officer arrested a black 15-year-old boy. And whatsoever was there, why they have been arrested, what was the cause of arrested, that is different. We are not to go into the facts, detailed facts. You all can read it out at your places. You can Google this case, even you can read it out. But I suppose that will be of less importance, because we have to constrain ourselves to the points which are relevant to the present theory, critical legal theory. So a white police officer arrested a black 15-year-old guy, and for some witness purposes, on account of relevant events differently projected at different times. When the case went to the court, the judge made a statement saying that police have been knowing to mislead the courts. Why so? Because there is an apprehension of bias. The judge was of the thinker. We are going to read a full-fledged article on this point today itself, which I have already quoted. Arrested injustice. Arrested injustice is that article which can be correlated with this. Judge made a statement that the police have been known to mislead the court because the Crown said that there is a reasonable apprehension of bias because a white police officer has arrested a black 15-year-old boy. Now the point in question is if there at the place of 15-year-old black boy, there would have been a white boy, whether he would have been arrested or whether he could have been arrested or not. The answer may be negative. That was what is meant by the judge or meant by the Crown Counsel in the court before the court of law. So the ratio which the takeaway from this case is that the statement made by the judge is not any impartial statement. It is something telling that what had been the experience of the judge in the past. Judge might be having an experience that police generally take account of acts of black people which may be pardonable by the police if those have been committed by the white people. So that was the experience of the judge. So with this experience in mind, he made a particular statement that police is trying to mislead the court. This is based on this theory that how the law is interpreted, that matters a lot. Of course, there is a dissenting opinion as well in this judgment itself, which you can mention as a passing reference to that, which says that the case should be decided not on the basis of, we should not, the judge should not look it at from the discrimination angle, but it should be based upon facts and evidence presented before the court of law. Of course, that is another way of putting the case or coming to a different conclusion regarding this particular case. So R versus RDX describes that it is a critical legal theory, how the judge interprets the law. It always carries the impression how the judge thinks about that particular point. In this case, a white police officer arrested a black 15-year-old guy. So this is the key fact and key point. So this is all about this critical legal theory. Do you have any question in your mind, or anybody has got different things to say?
No, sir.
Anybody else, please? I believe that everybody is getting, there are 25 persons in the class and everybody is good with this. And so I move on to next. Next means to say like, we have to move to the feminist legal theory. Now the word denotes itself. We are talking about women in particular. Now this theory is regarding the women's rights. We need to study this theory on the basis of one point, that of course it is something about the historical perspective, how the women were treated with respect to the electoral process in Canada. We are talking here about a particular process, that is how women were treated with respect to the electoral process in Canada. We will read this theory, feminist legal theory. You can jot it down from two aspects. One aspect is early feminism. We will read the person's case, P-E-R-S-O-N-S, person's case. Second is the contemporary feminism. Morgan Taylor case. Morgan Taylor case. Somebody has put it into the chat box. I'm really obliged and thankful to that fellow. I suppose Ashish is doing a good help of mine. Really thankful and obliged. Now let us see what this theory says. Feminist perspective, as I already told you, has been discussed in this theory. The women, we are talking about the past, women were treated not at par with their counterparts, their male counterparts. they were always at a disadvantageous position in this society. The idea in mind is that they were not made part and parcel of the decision-making process in the country's polity. In Canada, we are talking here about Canada, we are talking about foundations of Canadian laws. So women were not treated equal with men in the past in Canada. So feministic perspective on law look at the extent to which women are disadvantageous. They were kept at a disadvantageous position. They were always thought to be subordinates of their male counterparts. Of course, I will come to Mr. Ashish, Edward versus AG Canada. I have given the popular name first, Person's case. This is most popularly known as Person's case, early feminism. So once you know about the feministic legal theory, if women do not have the proper representation in the polity of Canada, then they are bound not to be part of the rule-making procedures in Canada. Let us discuss it from two aspects. First is early feminism. It is in the very earlier times prior to beginning of this 20th century. Beginning of 20th century means to say second decade, first or second decade of, even prior to that also, of 1910, 1912, 1913, prior to 1916. Prior to 1916, women were not allowed to vote. Vote means to say they never had any say in the decision-making process, in the polity of the country, politics of the country, or polity of the country, or say they were not part of the decision-making process, rule-making process. The first point was that when the representation or the protests were there, the protests were based on one single factor, that why the women are not allowed to vote. At that point of time, you may be surprised to know that even all of you may be familiar with that women were not allowed to, what to talk of contesting the elections or taking part in the electoral process. They were not even allowed to vote. So once they were not allowed to vote, it means they have no participation in the national life. So in 1918, Parliament passed Women, let not me be wrong, Women Suffrage Act 1980. Of course, if anybody has read Constitution of Canada, this was passed by British Parliament. So by this act, every woman who was over the age of 21 was allowed to vote. So this was, besides having other conditions, of course, those were not a part of this our syllabus. So I'm giving passing reference, but that by Women Suffrage Act 1918, British Parliament gave the rights to the women who are above 21 years of age, apart from having another qualifications, that they can vote into the polity of the country. They can be a part of the electoral process. The case is in this, as Mr. Ashish has already written in the chat box, Edward versus AG of Canada. 1930, this is the case, Person's case. So he has also put the name of the act as well. Thank you very much. And The question in this case was whether the words qualified person in section include a woman. This act was passed. Woman was allowed to vote. Then the next question arose whether the women were allowed to contest the elections or. Here was one word. You can write down that word, qualified person. Whether the word qualified person in that act includes a woman or not. Whether the woman can come under the definition of qualified person and become a member of the Senate of Canada. So this qualified person was the part of a law that is known as BNA. BNA Act. This was the act which planted in Canada a tree which could evolve itself, capable of growth, and within its, of course, natural limits as well. In this case, it was held that this qualified person only includes male persons. So the point is whether a qualified person includes a woman or not. It was held that it never includes a woman. So the woman cannot be part of the Senate of Canada. The court held that Parliament has only intentions whenever they frame the law that the word person, qualified means to say the qualification, which has something other qualifications. I have little problem in throat, sorry for that. Thank you. And those that word person does not include woman. So this is the takeaway from this. Then came the contemporary feminism. The second topic which we have discussed, which I have quoted you. It was the product of some 20th century feminism. I told you that in the 18, a bill was passed, women was given the right to vote. Then women, that is something you can also think upon these lines, that women have started thinking. Of course, they can give the vote, but they can only elect their male representatives for the purpose of Senate. And as I have already told you, the BNA Act word qualified person does not include a woman. So they should make an endeavor by which they should be allowed to become senators of Canada. Once they will be allowed to become senators of Canada, so they will be part of rule making process. Now, going a step further, the women started thinking that the women should decide about themselves. The women should, somebody wants to say something? No. Kindly mute yourself, please, for the convenience of others, all others. So once, just let me check it out. please. Once that has happened, now the question was whether the woman can decide all the factors about themselves. In 1988, by the time I told you from the beginning of 20th century, it came the end of 20th century, Charter of Rights were passed in 1982. Canadian Charter of Rights and Freedoms were passed in 1982. In 1988, a case called R versus Morgan Taylor. Yes, R versus Morgan Taylor, 1988. The question was, you can jot down this, whether section 251 of the Criminal Code was contrary to section 7 of the Canadian Charter of Rights and Freedoms. Whether section 251 of the Criminal Code was contrary to section 7 of Canadian Charter and Rights, Canadian Charter of Rights and Freedoms. As I have already told you, by this time, Charter was passed in 1982. Now the question came before the Honorable Supreme Court of Canada, whether section 251 of Criminal Code is violative of section 7. What is section 7? If you haven't read about Canadian Constitution, let me introduce you section 7. Section 7 talks about life, liberty and security of a person. I will come to the facts also, but let us examine that as per the contemporary feminism, the question before the Honorable Supreme Court was that whether section 251 of the Criminal Code was contrary to section 7 of the Canadian Charter of Rights and Freedoms. Now section 251 is no more there. Section 251 talked about that women cannot decide about themselves. That was the interpretation or conclusion which we can draw. The facts of the case was that three doctors were charged with carrying out an illegal abortion under section 251, subsection 1. The point was that the three doctors were charged for the offense of procuring a like abortion, or you can say miscarriage, contrary to section 251, subsection 1. Now, the court, when deciding this case, found that the provision section 251, subsection 1 is violative of the Charter of Rights. Section 7, Charter of Rights. Once the court held that section 251, subsection 1 is violative of section 7 of Canadian Charter of Rights, then the women became self-decisive about their pregnancies, whether to keep those pregnancies or whether to get away with those pregnancies. There is a one line which you can jot down. In that judgment, Wilson won. Wilson, Justice Wilson. You should write it down as Justice Wilson. Justice Wilson whether a pregnant woman can be compelled by law to carry a fetus or not, to its term, is the willingness of the woman herself. So by this judgment, a woman was made owner of the fetus which she is carrying in her womb. So woman had got all powers whether to carry that fetus or not depends upon her personal will. So we were talking about contemporary feminism, that the water has flown from the river to this an extent that women who were demanding voting rights in the year 1918 carried their war for their rights up to 1988, that the Honorable Supreme Court of Canada made them owners of their own fortress. They had every right to decide about their fortress. Means to say that they had became senators, they had became electoral voters, then they have become senators. Then the Supreme Court also ruled that the women are owners of their own body. So section 251, subsection 1 was declared to be violative of section 7. So section 7 of the Canadian Charter of Rights. This is a takeaway. Mr. Ashish has again written Justice Bretha Wilson. Well written. And if anybody has got any question about the fourth theory which we have read.
No, sir,
Today,
all clear.
all clear. Thank you. And today we have spent a lot of time on the other things as well, discussing about the basic things of foundation and Canadian laws. And in another 20 minutes, and we have started 10 minutes late as well. And next time we will be keeping track of the time, because time is the key to success in NCA exams. Let us go a little further. That law and economics. Last theory is law and economics. That whether this theory talks about that whenever a case is filed in the court of law, it takes time to be finally decided by the courts. And the value of the money changes during the whole time. And certain times the difference in the valuation of the money is so much that the money which a receiver gets is very much less than what he was supposed to get. Suppose a case is filed today and judgment came after 10 years, the value of the money changes for that person or that institution after 10 years. So whether after 10 years, the value of these damages to be given should be proportionate to the value of the money to be given at the time when it is decided. This is something balancing of money should be there or not. This theory talks about that the balancing act of the money should always be there. Whenever the person needs to get the money, it should be in proportionate to its value, which generally do not happen in other jurisdictions. But in Canada, this theory is somewhere it is prevalent. This is something everybody would like, that whenever he gets, say one is fighting for a compensation in a suit, whenever he gets that compensation be in accordance with the times when he is getting this. If he is getting what he earlier demanded from the court of law, then many a times it will be seen that it is of no use for the person when he is getting this. So this theory says that the money should be in proportionate. Balancing of money should be done. The case to be given in this theory is Bank of America versus Mutual Trust Company. Bank of America versus Mutual Trust Company, 2002. The facts of the case are very simple because this pertains to some technical facts, and in this case, the appellant, the Bank of America, had advanced certain funds to one mutual trust who was a respondent in the present case, who was a developer, and by the time like for the purchase of some houses, some money was given by certain persons to a developer, and that mutual fund truster backed out, never given the houses to the persons, and those persons approached the court of law. And once they approached the court of law, they it took a lot of time in the decision to be reached. And whenever the money which was advanced by Bank of America to that developer for building those houses was to the tune of millions of rupees, but the difference which came out to be of $5 million. $5 million was the different amount between, was a difference amount which came out when the decision was reached by the court. So the question was whether the judgment to be given should be in accordance with those, at the time when the case was filed, or it should be in accordance with the time when the judgment is delivered. So it was held that it should be in accordance with the time when the judgment is delivered, because balancing act of the money should be done, and value of the money should be in proportion to the times when judgment is delivered. Even I can quote you the fancy written technical language. Why I'm not going to that like technical language? I'm trying to portray you the whole case laws and their ratios in simple words. For the simple reason, once you will get my notes, you will have everything written in those notes. You just need to jot down few lines for the day as a matter of class notes, so that you should remember to quote the same in the exam. You should in a position to recall the same in the exams. Now, so this is all about 5 theories. Generally, if I am to say that what are the theories which are mostly to be quoted in the exams are, like if I am to say, if you are to write it down, the first few theories, 4 theories like legal positivism, natural law, critical legal theory, feminist legal theory. These are the most referred theories in the exam in most of this. Of course, law of economics, the last theory, is of less relevance since it pertains to a technical matters. You may not find much of the examination questions, but still, if you get a in these days, even the small questions are being asked by NCA. So you have the case law, you have the meaning of the theory, balancing act of the money at the time of the delivery of the judgment, at the time of the pronouncement of the award or the pronouncement of the order by the court of law. The balancing of the act of the money should be done by the courts. That is the takeaway from this case, and you have able to understand what is law of economics and what is the ideology before this theory. So I suppose you all are good with these legal theories. Still, I give you 1 minute to ask any question if you want. Please don't hesitate. You can ask any question. Every question is a good question, because in the exams, if you are facing any question which may not be in your capacity to cover it up, it will be difficult for you people.
Sir, in this kind of a,
One by one, please.
yeah, so sir, these theories, positive natural law, feminist perspective on law, critical legal studies, these theories, they will bring this question shall be asked in a form of a case studies, or means this theory has to be demonstrated by way of case laws by us in our answers.
I have covered it from your let me say you in from two angles. First, we should know that what is contained in these theories. Second is that I told you that theory needs to be written in every question, that this is something bonus marks which you will be getting in the exams. Suppose you have identified the main topic, you have identified the case laws to be quoted in the exam, but you do not get sufficient material to write, then of course there is one theory to help you. That is one way of putting. Another is the demand of the question is such in which you need to put one analysis of the problem from a theory aspect. Then you need to mention it. Another point is, another big point in this theory, in this describing the whole theory, is the case law with respect to each case theories. If there is an independent question, maybe of 5 marks, of 10 marks or 15 marks, then you should be in a position to write the whole question of 5 to 10 marks. Are you satisfied?
Yes, sir. Thank you, sir.
Somebody else was also trying to ask something.
I just put it on the chat box. Can you explain the difference between inclusive positivist and exclusive positivist?
I can understand, but this inclusive and exclusive positivist, do you know, you have done a lot for the class, so at the cost of time, I can explain it, but still, from where you have read it?
I was just reading the syllabus.
Okay, may I know, can you enlighten me as well? Please, I'm not pinpointing it. I just want to enlighten myself.
Yeah, it is in the theories itself, natural law theory.
No, it's a vast concept to be explained. If you have to go into detail into the inclusive positivist and exclusive positivist, then you have to cover different sort of things. Of course, we can discuss it separately, because this is something, two concepts, inclusive positivist and exclusive positivist. Because there are, in positivism even, there are two types of thinkers. One believe in one concept, another believes in another concept. We have tried to summarize the matter in such a manner so that we should not be in a problem in an exam to attempt the questions.
About the attempting the question, from next month, the time limit is reduced to 3 hours instead of 3.5 hours. And this is the vast subject. So your tips will be very valuable on that, how to minimize and utilize our time in the exam.
Of course, we will come to that, but I suppose this is not of much importance, because there are writers. If you go into books into inclusive positivist and exclusive positivist, or in different notes available into the market, there are 5 to 10 pages written on this. And that is why I'm not covering it up, because there is only a passing reference with respect to the positivism theory, which we have explained. Of course, you can call me, you can call me always. You can call me always and we can discuss. I suppose this is of less uses from the examination.
Okay, thank you.
Any other question before we go into the cases? And we have left with 10 minutes of this today's class.
No, sir, all good.
Oh, thank you. And let us go to the one case law, R versus Morris. Now let us open the syllabus. Even if we do not attempt all the exam questions and case laws today, we will shift it to the next class. But let us write down the key words for today's. Kindly jot it down on your syllabus itself. Let us mark R versus Morris as first case and 8573123 Canada Incorporation as the second case. Kindly on the left hand side, write down anti-black racism. So, because after the incidents which took place in USA, the whole chapter 1 of this NCA was amended. Earlier, these were not the case laws. When I studied, let me say you very frankly, these were not the case laws. R versus Morris came in 2021. Even Calais Shepherd Plaza Incorporation also came in 2021. Because all of a sudden there were, I shouldn't say these words, people or the courts have talking about the anti-black racism, which is prevalent in Canada. Of course, the article which has been written by Robert Maynard, Arrested Injustice, was written in 2017. So what I'm trying to say is that there was already learned views in the universities, in the society about the racism, about the discrimination being made against the black people in Canada. Not only in the society, but in the court of law, by the police, in the prisons, means to say justice delivery system. But when I won't name that fellow, in USA, a particular incident against the black has happened, then everything came on the forefront. And that is why the NCA had to take a step with respect to the anti-black racism. And these two cases, R versus Morris and this Calais Shepherd Plaza Incorporations, were included in this NCA syllabus. These were not part of my syllabus. I appeared in foundation exam in August 2020 itself, 1.5 years back. Now, on the right hand side, R versus Morris 2021, kindly write down sentencing case framework. Sentencing case framework. Whenever you find in exam regarding anything with respect to anti-black racism, sentencing case framework, you will be recalled about R versus Morris 2021 to be quoted. Then next case, landlord-tenant case. Of course, these two cases pertain to anti-black racism. First case is sentencing case framework. Second case is with respect to landlord-tenant case. Now you can put a single dot upon it and write down on the above of your sheet. This is the case by which judicial notice of anti-black racism in Canada needs to be taken. The court held that judicial notice of anti-black racism in Canada needs to be taken. What is in existence? What is in existence on the facts? What is in existence in the facts should be brought on record, howsoever indirect that might be. So you should put a dot upon their landlord-tenant case. That is for your memory. The takeaway of this case is judicial notice of anti-black racism in Canada needs to be taken. What is in existence in facts should be brought on record, howsoever indirect that might be. Now come to the third case, R versus Gladio, 1999.
Sorry, I want to know the case for landlord. I couldn't get that exactly. Once again, please.
Oh, yes, please. And the second case is landlord tenant case.
Okay, thanks.
You can write it down on the right hand side, and you can put a dot, and after putting dot, you can go in on the top of the paper and write down there, because detailed line needs to be written. Judicial notice of anti-black racism in Canada needs to be taken. What is in existence in facts should be brought on record, howsoever indirect that might be. If I am to give little view of this case, of course, we need to discuss this case since it's a part of our syllabus. The point was, if there was something which has been brought by one person, in this case, the landlord, which describes about racism, then judicial notice of that racism should be taken by the courts. And outcome of the case should be dependent upon that judicial notice. You will see in this case law that the whole structure was changed. Now let us write down against the before the third case. On the left hand side, R versus Gladio, April 23, 1999 was the date, which should be written on the left hand side. And on the right hand side, I have posted in the group as well, section 718, subsection 2, further subsection part E. Section 7182, I have put it in WhatsApp group as well. Purpose and principles of sentencing. This case is also known as Gladio sentencing. You can note down purpose and principles of sentencing, then you can put a semicolon and write down Gladio sentencing. Then you can put two dots up here, then you can go on the top of the sheet below where you have put one dot, note down restorative justice must be given particular consideration when dealing with Aboriginal offenders. Let me know anybody who has not spoken. I'm asking who has not spoken in today's class. Anybody who is an Aboriginal in Canada? We have a full-fledged topic on this, the second chapter on this. Anybody volunteering? Aboriginals are the native Canadians. Very simple words. The persons who are original Canadians. Of course, this is not the official definition. Official definitions goes with native Canadians. Those Aboriginals can be described as Indians, not Indians by nationality. Indian is a word to describe Aboriginals. Notice, of course, we will come. I do not want to go into details. It will take a lot of time. Our class time is already over. And last, Article 1. You should note it down. Article 1 on the left hand side, and then black racial discrimination. I will repeat what I have just spoken on the two dots. Two dots, you should write it down. Restorative justice must be given particular consideration when dealing with Aboriginal offenders. This is of utmost importance in today's times. And believe me, there will be a short question in the exam on anti-black racism. And whenever there will be a question, you have to analyze which case law is best suited, which part of this article needs to be referred in your answer. So I have tried to simplify these. Of course, we will spend half an hour in analyzing these three cases as well as this article in our next class. So in today's class, I have tried to summarize, I have tried to portray in detail the whole concept. I have closed down my syllabus. So you should always carry this syllabus with you in the class. That is my humble request to all of you. And once you take this syllabus with you in the exam and the words you are writing in your syllabus, this will make your exam very, very simple. Of course, I am going to tell you in later part of our classes that how it will be simpler. This is something methodological formula to attempt foundation exam. If you learn that methodological formula to attempt foundation exam, nobody can beat you. You can be master of foundation because that formula enables you to write the answers in the proper perspective. The chances of getting wrong becomes negligible. So in first class, I am telling you that in foundation class, the worst mistake which anybody commits is they write something else, but the examiner is looking for something else as a main topic. And this happens many times with everyone. If I am to attempt, even after knowing the whole of the foundation syllabus, I will commit the same errors. But if I will adopt the rule out methodological formula, then I am bound to succeed in this exam. This is something valuable tip from my side for first class. What is that valuable tip? We will keep on discussing that tip. We will keep on practicing. We will keep on doing practice of that tip in the days to come in our classes. Hope that you might not have felt bored and you might have enjoyed our class of the day. And I would love if you can put your feedback on our WhatsApp group. That would be so nice of you. And I always welcome the suggestions or always sorry for this. And I always welcome that if anybody has got any material suggestion with respect to the teaching. Why so I'm saying? Because we are like a family in this class and we have to cover the whole syllabus. And if you feel that these points should be included in my way of teaching, then I would be like loving those steps so that I can improve. This is my learning process. And even if I will be, say, holding my 100 class, I mean to say that I will be learning only. And this approach will be really better for everyone. Any questions before we say goodbye for the day? Thank you very much to all of you that you have been kind to spare some time for today's our first class, and hope to see you on next class next Sunday, same time. And after that, once we start our paid classes, then of course, we will have 2 classes a week. That is the information which I want to give. I have little throat problem. That is why I'm missing few words certain times. My flow will be better in the days to come. Next time, I suppose my throat will be better.
Thank you for the session. Thank you, sir. Take care.
Thank you so much.
Thank you.
Welcome to all, please.
Thank you very much.
Thank you very much.
Welcome.